And subsequently, my lord, perhaps after they adopt, we will also adopt our reply address.
Okay. Mr.
So,
Makanjwala.
Yes, my lord. Respectfully, my lord, the defendant's final address, my lord, is dated the
The
12th day
claimants.
of. I'm sorry, my lord, the claimant's
I think
final
you're used to
address.
defending that you're
My lord,
forgetting your claimants here.
my lord, I'm sorry, my lord. Yes, I'm apologies, my lord. I'm a bit flustered. I'm in court of appeal, so I have to run out to take this. My lord, the claimant's so defendant's contact claims final address is dated and filed on the 12th day of February 2024. 12th day of February 2024, my lord. My lord, in that address, we raised two issues for determination. My lord, I adopt all the arguments contained in our final address. And I most humbly urge this honorable court to uphold the claim of the claimant and to dismiss the counterclaim filed by the defendant. My lord, if I may just say a few words.
Yes, go ahead.
Thank you, my lord. My lord, this is a very, very simple case. My lord, it's a case where the defendant used to be the head teacher of the claimant. My lord, the claimant is a school. My lord, the defendant served on the claimant a notice of resignation, by virtue of which she gave the 2 terms notice required as per our employment contracts. My lord, for reasons best known to the defendants, she subsequently made a U-turn and served another notice again, my lord, where she then abruptly resigned her employment with the claimant with immediate effect. My lord, the truth of our case is that having not fulfilled the contract between the parties, the defendant is in breach of the contract he entered into with the claimant. And it is on this basis, my lord, as we urge this honorable court to resolve this claim in favor of the claimant. My lord, as relates to the counterclaim, my lord, our case is that there was no constructive dismissal. The defendant chose to resign for reasons best known to her. There was no constructive dismissal, and there is no evidence, my lord, pointing to anything that was done by the claimants that amounts to constructive dismissal of the claimant's employment. What my lord would find from the evidence and the records that the defendant points to allegations of constructive dismissal, where particularly one incident where the defendant purported to sanction or dismiss one of the teachers in the school, and the directors of the claimant stepped in to wade into the situation. At all material times, the defendant was given a free hand to direct and run the affairs of the school. So it is for this reasons, my noble lord, that we urge your lordship to uphold the main claim and to dismiss the counterclaim. My lord, in our written address, we've argued certain preliminary points. My lord, we've argued, for instance, that the address of the defendant's counsel, Mr. Salami, cannot by any stretch of imagination be equated with the evidence before the court. So my lord, we find, for instance, in paragraphs 2.1 to 2.6 of Mr. Salami's address, Mr. Salami purported to introduce matters that are not borne out of the records before my lord. My lord, we've also argued that certain exhibits, particularly exhibits D 34, 35, 36, 37, 38, and 39, were made in anticipation of this matter. And we urge your lordships to disregard those evidence because the law allows a court to expunge from its records evidence that ought not to have been admitted in the first place. And lastly, as a preliminary point, my lord, as it relates to exhibits D4 and D16, we urge your lordship to disregard them as no foundation was laid by the defendants. My lord, as a final point, as a final preliminary point, my lord, we've categorized exhibits D4, D5, and my lord, you find them on paragraph 36 of our written address. Exhibits D4, D5, D7, D8, D14, 15, 16, 18, 20, all the way to 39. Now, my lady, all of these pieces of evidence are all electronically generated evidence for which the defendant, for reasons best known to them, did not follow the required procedure in the Evidence Act for those pieces of evidence to be admissible. And it's for these reasons, my noble lord, that I urge on your lordship to uphold the main claim and to dismiss the counter claim. My noble lord, I know I have no right of reply, but just to specifically thank my lord for the opportunity and privilege of appearing before my noble lord. And my lord, as and I had indicated this, when Mr. Salami was not in the other matter I did for my lord, that we have a case stated from is a part of this matter, my lord. I went to the High Court, that is now at the Supreme Court, which essentially touches on whether the industrial courts or as the virus to entertain a purportedly defamatory matter that arose is related to or connected with the workplace. And I think that my noble lord's name will be etched in history when it turns out that the underlying employment matter was done in this court. My lord, I'm very, very grateful for the opportunity and the privilege to have appeared for this court, sir. I'm very grateful, sir.
Thank you. We'll be interested to know what the Supreme Court says. So if you can get us when the decision comes out, so that we all know where to stand. Thank
Yes,
you.
sir. We do, sir. Thank you, sir.
Mr. Salami.
Most respectfully, my noble lord, the defendant counterclaimant's reply address was filed on 17th February 2024. Respectfully, my lord, we adopt these processes in urging this honorable court to dismiss the claim and uphold the counterclaim. My lord, at the time I adopted, I thought we were just to adopt without any oral arguments. Without prejudice to that, my lord, I'd just like to reply to some of the things that have been said here. My lord,
you still have the right to reply.
Okay.
Go ahead.
I thank the court, my lord. My lord, the case presented by the defendant was that the defendant counterclaimant abruptly resigned. That case, my lord, simply is not borne out by the record. Or from a different perspective, it actually is borne out by the record. However, what the claimant has refused to say is the reasons why the resignation was abrupt. In our own duty to the court of candor, we have provided those reasons. And my lord, those reasons amount in law to constructive dismissal. And the court, my lord, doesn't need to take our word for it. Respectfully, my lord, may we just draw the court's attention, because what had been said was that there is no evidence before the court. May we draw the court's attention to Exhibit D16, which is a compact disc. We played before the court in a painstaking manner, such that the court had to accommodate us for almost an hour, listening to live reactions of the circumstances surrounding the constructive dismissal of the defendant's counterclaimant. My lord, in that tape, we saw that the claimant completely threw the defendant under the bus. My lord, I'm quoting the claimant. I'm quoting the reaction to parents of, to clients of the claimant. As soon as, my lord, issues were being discussed, first things first, the defendant was foreclosed from that meeting despite the fact that she was the head of school. And then at the meeting, she was completely thrown under the bus. As soon as the claimant had done it, the parents rose up in defense and said, why are you throwing her under? They were so upset. My lord, that is a direct reaction. And that is not even the defendant herself. The parents, who are not even the defendant, immediately took offense to what the claimant had done. My lord, there is no further evidence required of the circumstances under which the defendant was constrained, was impelled to resign. Clearly, the claimant had lost confidence in her. She could no longer continue. In all good conscience, and even contractually, she could no longer continue. My lord, when CW1, the claimant's sole witness, was confronted with this evidence, the court is owed to note her demeanor. I myself asked her, what is the meaning of thrown under the bus? And she couldn't dispute it. That is incontrovertible evidence before this honorable court that in fact and indeed, the claimant was thrown under the bus and was constructively dismissed. In everything said, my lord, the claimant has not gone near this aspect. And this aspect, my lord, is not a matter of address, it's evidence, my lord. I've not referred to any page of my address. I've simply referred to the document before this court, properly admitted. Exhibit D16, my lord, D16. And the cross-examination of CW1. That's the evidence, my lord. My lord, on this issue alone, this case can be decided. The court doesn't need to look at any address on these two pieces of evidence given by CW1 under cross-examination and Exhibit D16. This case can be decided. The question of whether or not Exhibit D16 was electronic evidence or not properly admitted by the court is a strange one, my lord, in view of the fact that we complied with Section 84 of the Evidence Act. In the defendant counterclaimant herself in oral evidence complied with the 4 requirements in Section 84 of the Evidence Act. Apart from that, my lord, any argument in that regard, respectfully, storm in a teacup in view of the statutory disposition of the National Industrial Court on the application of the Evidence Act. In the interest of justice, the court heard what led to the constructive dismissal of the defendant, as if the court itself was there. It's not reported speech, direct evidence, real evidence, my lord. On this basis, my lord, we urge the court to dismiss the claim and uphold the counterclaim. My lord, we thank the court.
Thank you. Okay. The judgment will be read on the 27th of January.
As the court pleases, my lord. My lord, we thank the court.
As the court pleases, we're very, very grateful to the courts. I know that we've put a lot of pressure on the court, but I thank the court nonetheless. Myself and my colleague thank the court for this. The ruling judgment this month means a lot to both of us, my lord.
Yes, my lord.
Thank you.
My lord, on my own part, I must align myself with the leader of the bar, Mr. Makanjola, and also confirm, my lord, my deep appreciation for the court bending over backwards to give us judgment within the circumstances. We thank the court, my lord.
Thank you. Okay. Thank you.